Greetings, and welcome to the DC Bar Pro Bono Center's Nonprofit and Small Business Programs podcast series. On a monthly basis, we talk to experts on legal topics of note to nonprofit organizations and entrepreneurs. I'm Daryl Maxwell, Assistant Director for the DC Bar Pro Bono Center's Nonprofit and Small Business Legal Assistance Programs. Today, we're going to focus our attention on for-profit businesses. We'll be discussing equity investing for small businesses, a legal perspective. I am pleased to welcome my friend and colleague, Rami Tarahi, to help us with this. Rami, a partner at McDermott, Will & Emery, represents private equity sponsors and investors in the structuring, formation, and operation of private equity funds, real estate joint ventures, and other private investment vehicles, as well as in connection with their acquisition and divestiture of portfolio companies and assets. Rami has had a varied career, including stints as an investment banker, presidential management fellow at the U.S. State Department, and associate at Latham & Watkins before joining McDermott. I'm sure most proudly, Rami has served for the last 7 years as a volunteer with the DC Bar Pro Bono Center, working with entrepreneurs at our monthly small business brief advice legal clinics. Rami is a double graduate of Georgetown University and Columbia University School of Law. Rami, welcome.
Thank you, Daryl.
You know, Rami, we talk to entrepreneurs at our monthly clinics about all manner of legal issues, but often the need for business owners is to address financing and funding. We could tell stories for days about funding opportunities that have turned out to be scams, hard money lenders, multi-level marketing schemes, Ponzi schemes, things like that. But generally, once friends and family investment has sort of run out as an option, business owners are trying to figure out what's next. And what I'd like to make sure to get into today is what are some of the investment opportunities and options for the business owners that we work with. And why don't we get started talking about sort of the different types of business entities that we work with and what's the most advantageous for them?
Sure thing. So, generally when you're starting off, with any business, the first thing you want to start thinking about is what type of entity do you want to form so that, in order to run your business. And, whether in DC or elsewhere, there tends to be sort of a collection of similar types of legal forms. All the legal forms in the United States are actually creatures of state law as opposed to federal law. So it really depends on the state you're in, and in DC's case, the federal district. Generally speaking, there's sort of a spectrum. You can start on the one hand with sole proprietorship or general partnership, which is the simplest type of form, and in fact, in many states occurs or exists whether or not you do anything. So if you do nothing, the default is that you are individually a sole proprietor. If you do nothing along with one or other partners, you're considered typically by default a general partnership. That has its pros in that it's super simple. There's flow-through taxation, so you're only being taxed once at an individual income tax level, and has very little, if any, requirements for ongoing compliance. The biggest downside to that form, though, or to those two forms, is that there's no limited liability. So in the event you find yourself, subject to a lawsuit or any other debt obligation, you could be liable personally for the liabilities of the company that you're forming. So that, we generally recommend, except for the smallest and simplest of businesses, that folks do not, go with the default because of the limited liability issue. It does create some real problems. Now, on the other side of the spectrum, completely the opposite side, you have corporations. Which I think most listeners are probably familiar with. That's what most of the large Fortune 500 or other companies that are listed in the stock exchange are formed as. This type of entity does have limited liability protection, so it's a crucial piece for shareholders looking to invest. They're not personally liable in the event that there's a lawsuit or that the corporation takes on more debt than it has the ability to pay. The downside of this form is that it has a lot of requirements. You have to have directors. You have to oftentimes have director and shareholder meetings to keep meeting minutes draft resolutions. On top of that, you also have there's also two layers of taxation. There's at the federal level, there's tax at the corporation level, and then later when you as the shareholder owner receive your dividends or capital gains, you also get taxed as an individual. So it's subject to what we call double taxation. So good stuff. Good part of it is that limited liability. Investors are typically familiar with this form. The downside is that it has a double taxation regime and lots of ongoing requirements. So for small businesses, we typically don't recommend the corporate structure, except for those looking to form a company that will eventually perhaps go public. But that's sort of the largest and most complex type of business. For most of the folks that we meet with in the small business clinic and sort of the folks thinking about forming a small business in DC or around this area, we would typically suggest that they consider the LLC structure. The LLC, which stands for Limited Liability Company, is a sort of hybrid corporate form that was formed sometime in the 70s and 80s in response to investor demand for sort of a different type of form. It marries the best of both worlds. It has both limited liability, just like a corporation, but has few ongoing requirements amongst the owners, and also only provides for a single layer of tax at the individual level. So it is really the best of both. And most small businesses today that are formed, and even some of the larger businesses, frankly, are starting to use LLCs almost exclusively as their main form. You can essentially, amongst the owners, decide whatever requirements you want, but you're not required to, as you would be under a corporate law regime.
So, Rami, let me ask you, we wanted to get in and sort of dig in quite a bit on equity investment and, using it as a potential sort of vehicle to get some additional funding for your business. Let's dive right in. What are we looking at? Should we be doing equity? Should we be thinking about equity investment? Are there different types? I'm gonna turn it over to you. Let's dig into what equity investment is.
Sure, and I think this comes up often when we're counseling businesses of all sorts, whether small or large. There's often a question of, well, what do I do to get financing? How do I essentially grow this business? When you start off, when you found a company, you typically do provide yourself some sort of equity into the company. And all equity is really, it sounds sort of like a fancy word, but all it really is an exchange of cash or assets for shares or interest in a company. So, in exchange for an ownership stake. So if you're the original founder, you own typically 100%. Let's say, in this case, you decide to form an LLC. You're the 100% owner of an LLC in exchange for some amount of capital, typically. Maybe $10,000, maybe $1,000, maybe $100,000, whatever that amount would be, you would get an interest in the company in exchange for that money. And the owner who does put in equity typically expects to receive dividends over time and a capital gains upon the sale of the entity to another person. When you go and try to source financing from third parties, so let's say you put in your $10,000. You've exhausted, that $10,000, and you need additional capital. Say you want to raise an additional $100,000 from investors. You'd go out and find your investors, whether they're friends, family, or third parties. And when it comes to equity, you're essentially, this is the really heart of it, you're giving them a stake in your company. So you're taking some of your company and essentially handing it over to these third parties in exchange for something of value, typically cash. Can also be an asset, but most of the time it's cash. And before we get into different types of equity, I want to distinguish this from debt. So debt is a bit different because debt, unlike equity, is not a situation in which you're giving any part of your company to a third party. Instead, what you're doing is you're contracting the third party. Let's say a bank or a friend who says, "Oh, I'll loan you $100,000. I don't want your company, but what I want is you to sign this contract, and I want you to pay me, 5 or 10% interest annually over the course of 10 years, So over 10 years, you pay them both interest and eventually their entire principal back. The nice thing about debt is you're not giving away any of your company. The downside is that your company is now indebted to some degree and has liabilities, which oftentimes that debt comes with its own strings and own requirements and conditions. So that's sort of the basics of equity versus debt. There's pros and cons to both, and we can go through that, in just a bit.
So if I decide, hey, I'm talking with a buddy and I've decided, well, I'm trying to think, is there a pro versus con, debt versus equity? I mean, I will say I usually counsel clients when I'm meeting with clients, if they can get debt, I usually would advise that debt's usually going to be the best way to go, just so that you're not giving up ownership. But in your expertise, do you direct clients one way versus the other?
Yeah, so it really depends on what the goals are of the person running the company. Let's say in this case, you're a founder. It's just you at the outset. There's nobody else besides you. You own 100% of the equity of the LLC. You're looking to raise money. I mean, I say in general, debt is probably preferable if you're looking to retain control over the entity. If you do go out and give people equity in exchange for money, you're almost always going to have to give some control up. People typically don't hand over money, especially significant amounts of money, without getting some level of control over the entity, because they want to know that their investment is being protected. So you may have to have some voting rights. You may have to give them a veto right over decisions. You may they may have the ability to fire you, if certain things go wrong. So all of a sudden, you're not really you're the founder, but you're no longer really the only owner of the company. You have multiple owners, and those can be friends and family. It could be completely third-party strangers as well. So I would probably agree that in most cases for a small business, debt is preferable. The hard part with debt is that for a small business with very little equity in it, it's actually quite hard to get debt financing. Most banks, unless you are fairly well capitalized as a business, are not going to just hand over money for even for a decently high interest rate. And when they do, it's going to usually be a very high interest rate. and I would say oftentimes they also will ask you, if you're a small business owner with very little in your business, they're going to ask you oftentimes to personally guarantee that loan, which means that even though you are trying to get a loan, on behalf of your company, you have limited liability protection and all that, the bank will say, well, great, but there's not enough money in that company for us to feel comfortable giving you a $100,000 loan. You've only got $50,000 in there and you've spent almost all of it. And so we want you to personally guarantee it. So you can, if you say yes to that because you have no other choice, which is oftentimes the case, right, you'll end up kind of blowing your limited liability indirectly because you just agreed to personally guarantee the debts of the company. So I find that for small businesses, that's a situation they oftentimes find themselves in. The other part too is a bank or a lender, whether it's a friend or a bank or a third party lender, will oftentimes include certain covenants or certain limitations or obligations in connection with a loan. So they may give you $100,000 and they say, but we expect monthly cash to remain at X level, or we want to be paid in this way or under these terms, and because they're providing you debt and no one else is, you don't usually have much of a choice, and you're oftentimes then burdened by this. It can also lead to a default, not because you didn't pay back the loan, but because one of the covenants wasn't met, sure, which sometimes can then open you up to having them default on the loan and then potentially collect part of the company, force you into bankruptcy. There's a lot of different things they can do. So there are some downsides to debt as well. But the big upside, of course, is Daryl, as you note, the big upside is that you're not giving up any part of your company or any control of the company. So that's really up to each founder and sort of each set of owners to decide for themselves.
So once you've decided and you're gonna take the position that I think I want to go, I want to extend an equity investment to a partner or to somebody who's going to get involved in your business, in your company. Let's talk about the different, or let's jump through the different types of partners that you may want to work with, or just, who might, as sort of a profile, might you be working with?
Yeah, I think for most small businesses, the first set of folks are going to be going to are people they know, in part because you got to establish a relationship with those people, and so there's an element of trust that exists that isn't necessarily true of a third party. The downside is they're people you know, and so when things go badly, you have to look at them every day for the next 50 years, and potentially have it may impact your relationship. And I've seen this happen even amongst fairly sophisticated parties. People are all best friends. They start a company, and all of a sudden they have real disagreements over what happens next, and they no longer speak to each other. They get at odds with each other. They sue each other. I mean, so that does happen, which is sort of unfortunate. I'd say the best way to prevent any of this is to agree ahead of time. Really spend time on the front end, going through the set of terms, and we'll get to this part a little later, to decide what overall provisions and terms and infrastructure should really govern your agreement. If you have a good initial agreement that's been really hashed out and thought through, you're almost always going to have less problems down the road by comparison to the opposite. But in terms of actual types of partners, you may find a partner who wants to go all in with you. So let's say you're the initial founder, you have a best friend or a friend that thinks that your idea is great and wants to both put in some money and or put in time. And so that type of partner we'd sort of consider to be an active partner, a true partner in the sort of the broad sense of the term. They're going to come in oftentimes for some amount of money, and also in exchange of services. So they may say, look, I'll give you less money, but I'm willing to work 20 hours or 40 hours a week on this, and I want to help grow this business. Great. You can decide individually how much you think that's worth. Is that worth 10% of your company, 5% of your company, 50% of your company? And that is really a negotiation between you and that partner or partners. You have to sort of think about, this is the first person you're negotiating with. When you bring in financing later or other partners later, you may have to give up more of your company. So you want to be really thoughtful, as to not give up too much control at the outset, because that's just the first bit of equity you are giving up. A little bit different with a silent partner, or typically a silent partner is only interested in financial return. They're not interested in being any part of the day-to-day of the company, but they do want some sort of financial return on their investment. With those folks, you may give up some control or voting rights, but typically it's of a high-level nature, where they want some sort of veto right, or they want ability to consent to a big transaction or a budget every year. But typically a little bit less than an active partner. It's a different type of situation. So you want to talk through your potential partner and figure out, are they really interested in just money? Are they interested in money but also want to be a real partner day-to-day in the business? What are they looking for? Because that's going to really determine how much of your own equity you're giving up and what type of rights you want to negotiate for and limitations with respect to your relationship.
One of the things that I get, one of the questions I get a lot is, I've looked into debt, bank's not going to fund me. I'm sort of trying to think about who I might want to bring on. And once you've moved past, right, the friends, the family, the sort of concentric circles, like outside of who you know, or who you went to college with, or who you play basketball with, or who is at your church, all these people who if things go awry, it's going to present like really uncomfortable sort of Thanksgivings, for example. Where, separate and apart from that, would somebody go? Where would they go to find investors? So, and I don't, again, I'm sure there's not like a magic elixir to find them, but for somebody who works with investors quite a bit, like if I've got a really great sort of idea, where do I go to find the right, and whether that means it's a silent partner or somebody who's looking for a great deal of equity, and I'm not going to Shark Tank, for example.
Yeah.
Where would I go to find somebody?
Yeah, I'm going to split this up into equity financing and debt financing, because I think there are really two separate buckets here. For equity, I would say for a small business, a true solid business, once you've exhausted sort of the friends and family piece, I think if you're looking for an active partner, you really want to be looking for somebody who is an established expert in their field. so that this person you're bringing on can actually add some real value. I mean, that's really the ideal situation where you're not just getting some money, but you're also getting the expertise of someone. And it can just be sort of high level strategic advice. It doesn't necessarily have to be, day-to-day, employee alongside you in the trenches, but somebody who actually has done this before, somebody who has managed to grow it in a prior business. So there are people sort of out there, and in terms of where to find them, it really depends on the industry. But oftentimes, industry conferences are great places to meet investors. If you're so lucky to be invited to sort of places where folks who are high net worth type or family offices congregate, those are also great places to find potential investors. Venture capital, sort of the traditional method for funding small businesses that now mostly sort of geared towards technology companies, but not necessarily exclusively so. Those are places where people try to find capital of all sorts. I think most importantly, when you go out and try to find investors, it's important to make sure that expectations are managed on all sides, so that you don't overpromise and find that yourself in a pretty terrible situation down the road. When it comes to debt, I would say first stop is probably your local or national, local branch of your national bank, or just a truly local bank. If nothing else, going to the bank and presenting them with your business proposal and your sort of capital structure. If nothing else, even if they say no to you, it's a great exercise for you to sort of walk through with a third party who has no interest other than making money. What is good, bad, deficient? What needs additional work on your end in terms of your business plan? What problems do they see? And they're not going to give you the entirety of sort of the detail of how they decide yes or no to whether to fund you, but it's certainly worth getting the feedback from a bank loan officer sort of from the get-go. The other thing is too, if they do provide you with a loan set of terms, you'll be able to have one contract that has both a potential interest rate and the set of terms that they're willing to agree to give you money. So let's say they say, sure, we'll give you a loan for 12% floating with all these restrictive covenants. Well, it's good for you to know that's what one party is willing to give you, having reviewed all of your books and records. So when you go out to a third party source, another bank, you'll have a basis for comparison. So okay, well, this is one set of terms I was able to get. Let's see if I can find something better. And for you, the interest rate may not matter as much as the restrictive terms. For others, it may be the reverse. So everyone has to sort of determine what matters the most to them. There also are outfits that provide third-party loans, sort of like investment vehicles that do this, but they typically focus on larger small businesses. So talking low millions or tens of millions, just because it's just not really worth their time on the smaller end. And on top of that, their rates tend to be higher than banks. They tend to look for truly desperate borrowers, and so you're not going to typically get a very good deal from them, and you're almost always going to have to agree to aggressive terms on their end.
I will also, to Rami's point about debt, oftentimes if you're not currently in a position for whether it be a larger national bank or a regional bank or a local bank to be able to get a loan from them, there are a number of lending institutions that provide microloans here in the district. I'll make reference to a couple here in DC. The Latino Economic Development Center is one that works with small businesses and loans from as little as $1,000. I think the number just went up. I think it goes up to about $200,000 to $250,000 that they're able to provide loan financing. The Washington Area Community Investment Fund does the same thing. Maybe not as high on the high end, and usually they will take into account the fact that you've gotten denied for a loan from a bank, and so they will take into consideration, bad credit score or the fact that you are a new business, which will usually make you close to being disqualified unless, as Rami mentioned earlier, you're very well capitalized, which most people aren't. So those are some things to consider as you're looking at a couple of different options. Now, I'd sort of get where we're supposed to be looking in terms of where we might look and then try to find investment. If we're trying to, two questions. First, if we're trying to sort of figure out who the right investor would be, what should we be looking out for? And then secondly, and this is actually, it's funny how much you can learn watching things like Shark Tank, is how do you then, after you're trying to figure out, all right, how do I evaluate this investor? And then additionally, how do I value my business in a way that makes sense? Everybody wants to imagine that their venture is worth, a couple $1 million. But just and we don't need to go super deep on sort of the tools, but sort of what do we do to sort of to properly value our business?
Yeah, I think it's really, and Darrell touched on this, a very important point. I mean, I think it's really important that, when you're going out looking for investors, that you really try to ensure that the person you're working with, or persons or entity you're working with, that you guys have a shared set of goals and interests in mind, or at least the goals converge in some way. If someone is only looking to make money, has no interest in your actual idea or in growing, your particular concept the way you want to grow it, I can assure you that down the road, when there's an important decision to be made, they're going to oppose, something that you want to do. And so you want to make sure from the get-go you have sort of shared values, aligned values. I also want to sort of note that equity investors in particular want to see a clear path to long-term growth, because they're not making money from being paid a fixed amount over time. They're not getting interest. Their growth comes from either sort of dividends over time, which usually aren't paid by smaller companies, at least not in the beginning. But more likely, they're going to be making their money from the company increasing in value in terms of its overall net worth, its overall enterprise value. And so, they're really looking for growth of the enterprise, both revenue growth, profit growth, all of it. And so the nice thing about that is that your interests are somewhat aligned when you're bringing in an equity investor, in that you both, the founder and sort of the third-party investors, have an interest in seeing the company grow. Where there may be a divergence is that those third-party investors may be only interested in seeing the company grow as quickly as possible. So it's important to ask them from the get-go, what kind of term are you thinking of? Are you looking for a 1-year investment, a 5-year investment, a 10-year investment? Because those, the exit that a third-party investor is looking for, and maybe also a perpetual investment, they may have no interest in ever selling. That term is going to affect how they approach the equity investment. And if they have voting rights or control rights, because you've given that up in exchange for their cash, you could find yourself in a situation where you want to continue to grow the business and they're interested in selling to a third party, or they're interested in, the company, if you get so lucky, IPOing. And so it's really important that part is aligned from the get-go. Debt investors, on the other hand, are only interested in the debt service. They don't really care, or are relatively agnostic as to whether your company grows, except for the fact that if your company is growing, it tends to have sort of a stronger basis on which to actually service the debt. Not always, though, because what they're really concerned with is cash flow month in, month out, in order to pay back the debt. If your company goes from being worth $1 million to $100 million, for most lenders, with very few exceptions, they still get back, and then they give you a $1 million loan, they still get back just $1 million plus interest. Whereas an equity investor who, let's say you had $1 million business, you sold half it for $500,000 to the investor, and it's now worth $100 million. Well, their $500,000 now is worth $50 million. So totally different, return profiles as between the two. And so, in terms of how to structure your own terms with those people, I mean, you have to sort of think about it from their perspective. The equity investor is really looking for long-term growth, so they want to understand when they're buying in, they're going to try to determine with you what is the current overall value of your company. And let's say, like we said before, we value the company overall at $1 million. If they want to purchase a 50% stake in your company, typically, though not always, this is all negotiated, they're going to pay you half of what the company is currently worth in exchange for those shares. Now, that number may be higher or lower if they provide you with services, maybe higher or lower depending on how desperate you are. So it's not necessarily the case, but that's going to typically determine what they pay for that interest. And remember, so let's say the $1 million company, now you've sold half of it, so you own half of it, and they own the other half. Let's say 2 years from now, it's worth $10 million, and you want to go, raise some more money. Now, your initial shares are going to be valued at, whatever they were times whatever the new value is. But when you go out to sell, you're going to be selling to new investors, diluting your existing interest, but at the higher valuation. So at each round, you're successively, selling to folks at whatever the valuation happens to be at that point in time. With debt, it's a little bit different in that what they're really going to be looking at is your ability to service their debt, how, what financial condition you are, how much cash you have on hand. And depending on all those factors, they'll decide how high of a risk you are. Typically, the riskier you are, the higher interest they're going to ask you to pay because they want to be rewarded for taking a greater chance and greater risk on you. Now, I think I should probably also note, just so folks sort of understand how this works, in the event the company goes bankrupt, this is also important for people to know, debt is always the first to collect. So debtors or lenders are the first to collect on a company when a company is being liquidated. So let's say a company's worth $1 million, it goes bankrupt, there's $100,000 left in assets. The lender is going to be the first person to be paid all of its money back, all of its principal back, before the equity owners get anything. And so, as we noted previously, the equity owners can potentially make millions of dollars on long-term growth of the company, whereas debtors only receive whatever they contracted for. The flip side of it is that in the event everything goes wrong and the company goes bankrupt, the debtors are the first people to get paid back. And so there's a inverse relationship between the risk you're willing to take and where you fall on the capital structure in terms of your priority of being repaid.
I look at the difference between equity and debt, like the difference between being a fan of a football team and owning a fantasy football team.
Yeah.
I am a New York Giants football fan. I live and die with how they do when they're terrible, like they are this year. When they're good, much like an equity investor, is riding the wave up and down, supportive, hopefully willing to give at a moment's notice. Whereas if you're looking to collect your interest every month, or you're looking for your, such and such on your team to score, irrespective of how their respective teams do, all you care about is the points. All you care about is the percentage that you're getting back. And I think it's a good sort of way to illustrate the difference in sort of participation in one investor versus another. So I want to make sure we get to some of the nuts and bolts of how to protect yourself, how to make this agreement, and sort of what, on a high level, what are some of the things that we need to get to make sure that the investor is protected, but most importantly, that the business owner is protected when they enter into one of these agreements.
Yeah, and this is really, I think of all the things that we deal with, whether the small business clinic or with my own clients, the operating agreement or the agreement between the owners of the entity really governs. It's sort of the Bible of the company. It is the thing that sets all the rules. It has all of the provisions that both protect and provide you with the rights. And so it really is important, as I noted earlier, that the owners, whether the existing owners or when new investors come in, the new investors with the existing owners spend some real time making sure that the terms are ones in which they all agree on. So some of the things that come up, are, what happens in the event of a new investor coming in? Who gets diluted? Is it everyone pro rata, or do some investors get diluted more than others? Who gets to decide whether to admit new investors? Now, is there a vote? Is the vote majority, supermajority? Is it unanimous? So, that's sort of an important piece. How much time and attention do the owners have to pay to the company? In some instances, there's a requirement that you provide at least 40 hours a week of work. Some it's substantially all of your business time. In some cases, it's nothing. It's just money. And so, that's also important to determine up front, because that could lead to some real misalignment down the road if you aren't upfront about what that looks like. Are there any conflicts of interest? If, can the person investing in your company, can they invest in a competitor down the street if they find a better deal? What if they're trying to just invest in everybody who does this in the city and say, well, we'll see which one works out? So for some owners, that may be okay. For other owners, that's a big no-no, and they'll say, no, I want you to be all in on my business, not on any competitors of mine. If you have owners coming in who are working alongside you, or potential long-term employees alongside being owners, because you have to consider whether you want to include a non-compete clause. Are they able to work at a similar business, X number of months after they leave your business? How about, there's also what we call tag along and drag along rights, which are probably a little more complicated than most people need, but they are essentially just distilled down to is, if you decide you want to sell the business, let's say now you've taken $1 million business, you've gone into $10 million, and you say, you know what, I'm good with that. That's a pretty good return on my time. I want to sell to a third party, some third party company that's bigger than me wants to buy me and take my customer base or my intellectual property. Do you have the right to force your co-owners alongside you on the sale? Or do they have the right to say, no, I want to keep my piece? When you're trying to sell to a third party, oftentimes third parties want the entire enterprise. They don't want just part of it. And so, that's called a drag along right. There's also tag along, which is the reverse. Meaning if somebody wants to sell, you have the right to also tag along with that main owner. Just generally voting rights. I mean, really, this is going to come up throughout the operating agreement. Who gets to do what, and what threshold does it take to decide? So when you're negotiating, for giving away equity to other investors, oftentimes that comes with control rights. It can be the same pro rata. It can be like you give away 50% of your company, so you give away 50% of your control rights, but not necessarily. You can give away less control, more control. You can negotiate this piece. But in most cases, control sort of follows money, although not always. And so this is important throughout the agreement. Who gets to decide on all of these important matters? And you should set that in there, both in terms of what kind of vote it is and what percentage is required. Is it 50%, 70%, unanimous consent? And it can vary depending on what it is. You can say, for admitting a new investor, 50% have to approve the admission of a new investor, but for dissolution of the company, you need unanimous consent, because everyone has to be agreed that they want to dissolve the company. Also importantly, what happens in the event that one investor wants out? It shouldn't be the case that creates sort of a collapse of the company. Typically, there's some sort of transfer right, and it can say you're now allowed to transfer without the consent of the other partners. It can also say you can transfer so long as you find an appropriate third party, or we, the current owners, have the ability to buy you out first at a fair valuation. So there's all sorts of things you can use in order to sort of buy out somebody who wants to leave. But it's really important that you get that set out, from the get-go, because you don't want to be having that conversation when somebody's upset with you and wants out, and all of a sudden there's no real mechanism for how to transfer their rights out, their interests out. That typically leads to lawsuits and real problems. And so those are just some of the rights. I mean, you can also include vesting clauses as well. If someone is working alongside you, actively managing the company, you can say, okay, well, look, I'll give you X amount of equity, but it vests over time. So if you're here for 1 year, you get 25%. You're here for 2 years, you get 50%, 3 years, 75%, and 4 years, you get the whole thing. So you help incentivize that person to stay, for a certain period of time in order to earn essentially the equity. That's more common in an employee context, but it can also come up in a context where someone's providing less equity, but providing you with services, as part of their equity grant.
So I've got two more questions for you. One, I'm going to preview that one I want second. The first question I'm going to ask is sort of, once you've reached sort of the end of the relationship, sort of where do we go? I mean, I'm sure most of that will have been hopefully prescribed in the operating agreement, or if it's called investment agreement, or investor agreement, or an equity agreement. But the other question I want second is, do you have an interesting or funny example of either a case you worked on or a case you're familiar with, to protect the innocent, of course, maybe not a case that you've worked on recently, that would illustrate some of this and maybe help give sort of like a closing lesson to the folks listening? So first, how does a relationship sort of end? And then if you've got sort of a interesting closing matter.
Yeah, so in terms of relationship ending, I mean, I often tell people like, this is probably the most important part to in some ways. I mean, people, it's sort of like, the way humans are with their own mortality. You don't want to think about it until it's too late and everyone else has a test to clean up your mess. So it's better to not, leave your relatives and loved ones with all the cleanup thereafter. I mean, it's much better to set, in a very straightforward, clear manner, what happens when I'm gone. And so with a company, sort of the same thing. You want to really sort of agree ahead of time what this company's term will look like. Term meaning that the length of time it's going to be in existence. For some companies, it's going to be perpetual. It's going to never end. It's just going to go on until it doesn't go on, until everyone decides it no longer goes on. For some companies, it's it'll be a finite period of time. They'll say, well, I want to create a company for 10 years and I want to cash out at that point, whatever it's worth. That's more common sort of in certain industries than others. I would say most small businesses that are set up as true operating companies typically have a perpetual existence because they don't really have a sense of like when they're going to be, at a point where they can sell themselves or dissolve themselves and distribute the assets up to their partners. So, that part's important. When you do decide to terminate, so whether the partners agree to terminate the relationship or whether, you're forced to by virtue of a bankruptcy, typically what happens is the liabilities are first paid off. So if the company owes anything to a third party, whether it's a lender or a supplier or whomever, there's typically a pecking order, as I noted earlier, but the debtors, the lenders get to first get paid off before anyone else touches any bit of the money. The assets are sold. And then if there's any surplus left over, that surplus is distributed to the owners, pro rata. And then after all that's done, then the entity is actually terminated in that state or dissolved in that state. And that's typically done by filing certificate of dissolution in the state. So I go say the other thing too is it may not be the case that the company is necessarily the relationship ends just as a result of this dissolution. You can also decide jointly together to sell your company to a third party, and essentially that company no longer exists after the sale or can no longer exist depending on how it's structured. And you may either cash out by being paid for those shares, or you could end up receiving shares of the new company in exchange. And that's sort of usually an end goal of a lot of small companies because at some point they run out of steam in terms of being able to grow their business without the infrastructure of a much larger company. So give you an example, a lot of those companies that became bigger companies were first very small companies like an Instagram and whatnot, and got bought out by a bigger company like a Facebook that had tons of capital and the ability to invest a lot more in the infrastructure of those smaller companies. So they'd offer the founders, and usually at that point the founders had sold to a bunch of other people, so a lot of co-founders and co-owners, a certain amount of money in exchange for ownership of the new entity. Now that entity becomes folded into the new bigger business and all this, and so it sort of still exists, but is now part of a much larger company. And that's a very common model today, even more common, frankly, than the IPO model that was, I think, more common a couple of decades ago. So today, everyone's looking to sort of grow something, create some value, and then sell to a bigger company. That's a really common sort of exit strategy for a lot of investors. So whether you decide to dissolve because you want to or because you're forced to, or whether you sell to a third party, that's typically the way a relationship comes to an end amongst equity owners. In terms of stories, lessons learned, I have to be probably very careful here because these things tend to have a way to they don't really disappear in terms of people's memory banks. But I will say I have worked with fairly sophisticated investors, and I'll leave it at that, who came together, one set with all the money, one set with all the expertise, the expertise tend to, reside within someone who was younger, hungry, really, had a real passion for something, had done it for years within a larger company, wanted to go do his own thing. The third party money came from folks who, had made money, didn't really have as much expertise in the particular business he was doing, but had the capital to back him. Needless to say, this devolved into something not particularly constructive. And part of the lesson he took out of it was, and we were talking about this later, it turned into acrimony, potential lawsuits, locking people out of the office, someone crying in the middle of the parking lot, lots of really crazy stuff. And, the lesson learned was, don't think that because you have less leverage that you should say yes to the first person who shows up with a checkbook. It may be the case that you don't have many options, and someone shows up with $1 million, $10 million, whatever amount of money check, and says, sure, no problem, I'll give this to you for X. You are going to have to live with the consequence of that decision until the company comes to an end. And if there are certain things about that relationship, and this is really almost at a sort of more of a personal level, but if there are certain things about a relationship that strike you as off or problematic from the get-go, or personalities that are problematic, trust your instinct to some degree. And I would say, be careful who you partner with, because it is hard to get out of once you've done it. And if nothing else, make sure that your agreement with that person is rock solid in terms of protecting your interests, so that in the event that person turns out to be not what you thought they were, or turns out to be exactly what you thought they were, but not in a good way, you have the ability to either push that person out, buy that person out. The more flexibility and optionality you can give yourself, the better off you're going to be in the long run as a founder of a company. So I think that's probably the greatest lesson I've learned so far in my time doing this. And I say this no matter what the size of the company, small or large.
Well, Rami, thank you very much for your time and your expertise today. This has been really helpful. I think this will be a great resource for lots of the small businesses that we work with, and this will be available for folks to review on our website. I'll make reference to, if you're interested in this podcast, obviously, or other webinars and other useful information from the DC Bar Pro Bono Center, you'll be able to find that information at www.lawhelp.org/DC/CED. You can also find us on Twitter at Darryl J. Maxwell, DARRYLJMAXWELL, at DC Bar Pro Bono, DCBAR Pro Bono. Thank you very much for joining us. Have a wonderful day.